Hi, Gene Zweben from Zweben Law Group. Today I want to talk to you about negligence. Negligence basically means that the person involved in an accident that caused the accident did something that they weren't supposed to do. Basically, they did something that was not reasonable under the circumstances. So, for instance, in a car accident, if you're stopped at a stop sign and somebody hits you from behind, they breached the duty of care to you to act reasonable in that situation, meaning that they should have been paying attention and stopped in time. In Florida, we are a comparative fault state, but it recently changed. It used to be considered a pure comparative fault state, but it's a modified comparative fault state. That means that in Florida, you basically weigh the negligence between the two parties. For instance, if you were partially at fault for an accident, but another party was partially at fault, your claim for damages is still valid, but it would be reduced by the percentage of fault you were in contributing to the accident. So now in a modified comparative fault state, that basically means that as long as you are 50% or less at fault, you can still collect your damages. However, those damages are reduced by the percentage of fault that you were found to be by a jury. But typically, in a case where you're in a car accident or a slip and fall case, you can show that the other person was fully at fault. You should be able to recover all of your damages. I know it's a little bit confusing. I'm more than happy to explain it further. If you have any questions, feel free to give us a call here at Sweden Law Group.